Good evening and welcome to the Ysleta Independent School District Board of Trustees Special Meeting. In accordance with Ysleta ISD Policy BED, this meeting is open to the public and is invited, and we invite citizens to offer comments during the designated citizen input portion of the agenda. Please note that the board will listen to the input, but is legally restricted from discussing or deliberating on the matters presented during this time. This meeting of the Board of Trustees is called to order at 6:01. We have a quorum with Trustee Hernandez, Trustee Haggerty, Trustee Woodruff, Trustee Ochoa, Trustee Rivera, and myself, Trustee Bustillos. Trustee Woodruff, please lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. Let's have a moment of silence. Thank you.
Trustee Woodruff, do we have any citizens' input this evening?
Yes, Mr. President, we have Jeff Senior.
Good evening, President Bustillos, Board Trustees, and Dr. De La Torre. I'm encouraged to see that the school board recognizes the importance of representation rights throughout the disciplinary process for district employees and is willing to engage in meaningful discussion on this issue. I'm also glad to see the district is open to discussing representation rights for its employees and taking steps towards addressing concerns that many educators and staff members have had for years. Representation is not simply a procedural matter. It is about ensuring employees are treated fairly, respectfully, and with due process throughout the course of their employment. For many years, teachers in Texas have seen important workplace protections narrowed by decisions from the Texas Supreme Court. In contrast, other public employees, such as firefighters and police officers, continue to have clear representation rights and protections in disciplinary matters. Educators deserve the same level of fairness and respect when navigating employment concerns that may impact their careers, reputations, and livelihood. Currently, teachers have little to no guaranteed right to representation prior to the issuance of discipline. That reality creates an imbalance that can leave employees feeling unsupported during some of the most difficult moments of their professional careers. Having the ability to seek representation before disciplinary action is finalized is not about avoiding accountability. It is about ensuring transparency, consistency, and fairness in the process for everyone involved. I understand the board may consider modifications to the language surrounding representation rights, so long as there are no material changes to the spirit and intent of the policy. It is important that these protections are not only discussed in principle, but clearly established in written policies so employees fully understand their rights and expectations. Having this language formally included in district policy would provide consistency, accountability, and a reassurance that all employees will be treated fairly throughout the process. At the end of the day, the true measure of a district is not only found in academic performance or public recognition, but in how it treats the people who serve students every day. Teachers and staff dedicate countless hours to supporting the success and well-being of students, often going far beyond what is required of them. They deserve a workplace culture that demonstrates the same commitment to care, respect, and professionalism in return. By continuing this conversation and working collaboratively toward fair representation rights, the district has an opportunity to show employees that their voices matter and that they are seen as partners in the success of our schools. Putting these protections into written policy would be a meaningful step toward building trust, strengthening morale, and supporting a positive working environment for all employees. Thank you.
Next, we have Jaime Abetia.
Good evening, trustees and Dr. De La Torre. I'd like to begin this evening by being very clear about what the union sees as the intent of this item. The proposed protections are not about shielding bad employees. They are not about protecting anyone who violates the law. And they are certainly not about interfering with the district's legal responsibilities. Any suggestion otherwise is inaccurate, unfair, and frankly insulting to the educators and employees who serve this district every day. The purpose of this agenda item is straightforward: to ensure district employees have guaranteed representation and basic due process during disciplinary and investigatory meetings. That is what the language says. In fact, the context of meetings is repeated throughout the proposal. Within just the first two sections alone, the word meeting appears in nearly every paragraph and throughout the item. In fact, throughout the entire item, it appears 17 different times. The intent could not be more clear. These protections are tied to meetings and the disciplinary process, period. Nothing in the language prevents the district from fulfilling mandatory reporting requirements to law enforcement, child protective services, or any other agency. Nothing delays those obligations. Nothing creates new barriers, and nothing takes away from the district's authority to act immediately when legally required. The proposal explicitly preserves the district's legal rights and representations. Concerns about administrative burden or delayed reporting are difficult to reconcile with the actual plain language of the item. Respectfully, those concerns are not supported by what is written here. What this resolution does is affirm that when an employee is called into a meeting that could affect their livelihood, their professional standing, or their career, they are guaranteed representation and a fair process. That is reasonable, that is responsible, that is measured, and that strengthens trust between the district and the employees who show up for the district every day and for students. We respectfully ask you focus on the language in front of you, on what it actually says, and vote in support of these protections for YISD employees. Thank you.
And that's everyone.
Thank you. On to policy action item, consideration on action on proposed amendment for policy DGBA, local regarding employee representation rights. Is there any discussion?
Mr. President?
Mr. Haggerty.
I have a few points to talk about regarding the board communication that was sent out May 26th that deals precisely with this board policy, where the administration put out 9 different items, and I would like to address each one of those 9 items. Where admin says meetings with supervisors could be delayed up to 10 business days because an employee wants a representative present. Excuse me. Section 3 of the resolution states that the meeting can be paused, rescheduled, or continued as necessary, but that 10 business days is a maximum cap, not a minimum. The provision only triggers the meeting that may result in discipline, termination, or adverse personal action. A routine supervisor check-in does not qualify. So my point is there's a ceiling on delay, not a floor, and it only applies to proceedings that could lead to adverse actions against the employee, not everyday workplace conversation. Where admin says the policy could delay mandatory reporting of child abuse and inappropriate relationships, what the document actually says, the proposal covers proceedings that may result in, contribute to, or precede discipline, termination, non-renewal, suspension, demotion, transfer for cause, or other adverse political action. Mandatory reporting to law enforcement or to DFPS is a legal obligation independent of any HR disciplinary process. Reporting a crime is not a grievance hearing. If the administration is suggesting this policy would prevent them from reporting child abuse, then they are conflating two completely separate processes. Nothing in this proposal touches mandatory reporting obligations. Where the administration said current policy disallows a mini-trial at the grievance stage equally, adding witnesses and cross-examination could burden parties and delay outcomes. Amendment 2, which is on page 10, keeps the mini-trial prohibition. It does not remove it. It adds a specific carve-out for enumerated procedural rights: representation, evidence access, witnesses, and symmetric accommodations. The existing restriction is preserved, and the amendment works within it. Where the administration says representation during closed session presentations could violate the Open Meetings Act and waive attorney-client privilege. Section 2, Item 6 of the resolution explicitly states, except where representation would be prohibited by law. The proposal already anticipated and addressed this. Where administration says TASB Legal Services confirmed no other Texas ISD out of 1,029 has adopted this policy, this type of policy deviation. What the document actually says, the legal authority section, pages 4 and 5, cites Texas Government Code section 617.005, Texas Education Code section 11.171, and Texas appellate case law, including Sire versus Mullins. The proposal is grounded in existing Texas law. The board has authority under TEC 11.171 and its own governance powers to set local policy. Being first is not a legal argument. Every Texas employee's rights existed before the first district codified it. YISD would be leading, not deviating. Where Edmund says, without more information and clarity, the policy changes being proposed could create inadvertent and unnecessary compliance issues. What the document actually says. The legal authority section, page 5, explicitly states the resolution does not rely on federal private sector labor law. Again, everything is grounded in Texas constitutional, statutory, and case law. If the administration believes there is a specific SB 12 conflict, please identify the provision. Without more information and clarity is not an objection, it's a stall tactic. Where Edmund says the right to representation at the campus level falls outside the scope of DGBA. The document actually says TGC 617.005 says public employees can present grievances individually or through a representative. TEC 11.171 affirms representation rights. Amendment 4 ties investigation representation specifically to investigations that may result in adverse personnel action against the employee. Telling an employee they can have a representative at the hearing, but not at the interview that builds a case against them is procedurally hollow. This is exactly the gap this proposal fills. Where admin says further review is required of other YISD policies, administrative regulations, employee handbook, and related employee trainings, the document actually says the fiscal and operational notes on page 16 already address this. Implementation requires updates to administrative regulations, handouts, training, and the website, all of which can be accomplished within existing budgets and within 30 days of final adoption. The key point is the administration is describing normal implementation work as if it were a barrier. Every policy change requires handbook and training updates. That is not a reason to vote no. It is what happens after you vote yes. Thank you.
Yeah. Anybody else would like to say anything? Mr. Rivera? No? Go ahead.
Yes, we just got this, the reply from TASB, I think you said on Tuesday, right? The
26th, yes.
26th. And there was a lot of recommendations, a lot of changes in it and everything else. And I know Mr. Haggerty just went over some of them, but at this time, I don't feel comfortable enough to recognize or understand every other changes that he just stated, which are the 9 amendments, I believe. I think we need to look at this a little closer so we can fully understand the impact to the district, actually more to our students as well as our teachers. I worked at a union when I was in the railroad for 18 years, so I know how important representation is, especially when you're called in for something. But I think with that, we need to be careful and be right in doing this. I'll support that, but I think we need more time to fully understand the impact this will have on the district and what it will have for everybody that's involved.
Mr. President? Mr. Rivera, do you want to say anything?
You know, I fully support this resolution, but I believe that our employees should have that playing field. But I guess just like Trustee Cruz will show us, we need to look at it a little further as far as that's concerned, because there's gaps, correct, when between the offense that takes place within the campus and the discipline itself. So that was my concern. My concern is the safety of the kids, as all of us should do. And we should, with this, all that important issue is that we should also take care of our faculty members as well. Because, you know, there's sometimes they're charged with serious allegations where there has to be separation. And we can't afford to have that gap of 5 to 10 days and have both parties at the same campus still. So I will ask the Eagle if we can you can give me an opinion on this as far as that's concerned, concerning these serious allegations and you know, the fact that they want representation for that. Which is possible?
Mr. Selfie?
Mr. Rivera, I'll be pleased to try to answer. Could you rephrase the question, please, to let
Yes,
me know specifically what it is?
Yes, if a faculty member is accused, or employee of the district is accused of serious allegations, is there, how should I say, can that employee still be removed from the campus and for the safety of the child or student involved?
Well, yes, the district, in coordination with the campus principal, always has the right to reassign an employee if it's felt to be in the best interests of the campus or a particular student or a particular employees. Pending an investigation, they can be reassigned to another position. They can be suspended with pay if they're a contract employee. But yes, the district has that inherent right to transfer, reassign temporarily or otherwise employees. That's correct.
Okay, and that's only, my concern is only for the serious allegations as far as that's concerned. Like I said, I support them having a representative for whatever disciplinary measures are being taken for lesser offenses and stuff like that. So, thank you, thank you for that answer. Appreciate that.
Thank you. Sure. And then we'll be back to you. Yes. Ms. Woodruff?
So my question is also to legal. It was brought up in the board communication that there might be gaps, and I'm assuming you read that because I can't repeat it by memory, sorry. Is that possible, or is this something that we need to be concerned about?
Ms. Woodruff, in terms of gaps, I'm not sure exactly what's intended by that. I do think there are some things that are in the resolution that, if it's adopted, ideally would be placed in a somewhat different policy, such as DC or another employment policy. because DGBA itself deals strictly with the grievance process. I'm not sure if that's what is meant.
Actually, I'll just read to you what it says, if
Yes,
that's
ma'am.
okay. That'd be helpful. It says, "Without more information and clarity, the policy changes being proposed could create inadvertent and unnecessary compliance issues." So basically,
Yes.
I said the wrong thing,
No,
so.
no, you didn't. I understand now. I think that's focusing in on under the resolution would give employees the right to, of up to 10 business days to obtain representation from the point that the employee is advised that, there's an investigation that's being initiated that could result in disciplinary action of the employee. And that has what I would call a ripple effect, or maybe an unintended consequence effect on several other policies. DGBA local itself provides that from the time of the grievance conference, the level 1 grievance conference, the supervisor who hears the complaint is supposed to issue a decision within 15 business days of the level 1 complaint, of the conference on the level 1 conference. So if at the conference the employee complains, say, about another employee, and the supervisor says, well, now I need to interview that employee, well, and then the next day contacts that employee and it says, well, I need representation, and it takes 10 business days, then by the time that employee is interviewed, 11 business days of the 15 business days have already been consumed. And if that employee on the 11th business day, and this might be an extreme example, but if that employee says, oh no, this is a case of mistaken identity, you need to talk to this other employee, well, you can see that the timeline would get out of hand. Now, even a more drastic timeline is that in DIA, which involves sexual harassment of employees, and FFH, which involves sexual harassment or abuse of students. And those policies both provide that from the time that the complaint is made, a decision should be made within 10 business days from the time the complaint is received. It does say that that 10-day deadline can be extended under extenuating circumstances. And the board policy on the 15 days, it says that it can be extended, the 15-day, by mutual agreement with the grievant. But the employee complained about doesn't have any say-so on extending that deadline. Well, anyway, under DIA and FFH, sexual harassment, these are high-priority items. The response time of 10 business days is really pretty short, particularly since in the sexual harassment context, sometimes there are no witnesses other than the victim, the complainant rather, and the respondent. And so, the victim presents a complaint, the respondent's interviewed. That's pretty much the end of it. But sometimes there are witnesses. And sometimes there are witnesses that may feel that, well, wait a minute, where's this investigation going? Is it going to implicate me somehow, that I was sort of a party to this? I think I need representation. Well, if they take the full 10 business days, which is a maximum, but if they take the full 10 business days, that blows that deadline totally, because it's a 10 business day deadline in the policy. So I think those are some examples of of that. Now, another example is student discipline hearings. Well, under your student discipline policies, from the time that a student is removed from class due to an alleged disciplinary issue, there needs to be a conference within three business days with the student, the parent, and the teacher.
And does that coincide with this policy that we are, because that sounds like that's a student policy and not an employee policy?
Well, sometimes in the context of student discipline, you can have a student or a parent say, no, it's not the student's fault, it was the teacher's fault. And that very often arises in the context, that issue of finger pointing often arises in the context of a physical confrontation between the teacher and the student, which can occur. And so in that context, the teacher may be the one that refers the student, but then when the student or parent turns around and alleges, no, it was the teacher's fault, the teacher started it, then that teacher, well, is going to want representation, and that's another deadline that would be blown if they take the full 10 business days. So those are examples of how the 10 business days, if the full 10 business days is taken, could affect timelines in other policies.
So I just want to say that I do support the right of teachers to have representation. That is very important to me, but it does look like we need to look at this a little deeper just to make sure that we can adjust this policy to where that it doesn't affect these timelines. So that's just kind of my opinion.
Mr. Hagerty? Oh, go ahead.
Mr. Asafi, that student policy you were referencing, is that a legal policy or a local policy?
On the 3 business days, that is in both legal and local.
So then legal supersedes local, so it would have no bearing. The student policy would take over, so the 10 days would be moot anyway, correct?
I think that's right. I think you'd have to go by the legal policy. That's
So
correct.
what I'm trying to figure out is what it is exactly that the administration does not like about this policy and why they do not want teachers to have this equal footing when it comes to being able to have representation. In regards to Mr. Ochoa's comment that all of these things here were given by TASB, that's false. If you read it, it says TASB Legal Services has also reviewed the policy changes, and all it says is this type of policy deviation by any of the 1,029 Texas ISDs, nearly all of which are TASB members, none of them have done it. That's all it says that TASB said. Everything else was prepared by Priscilla de Mata, Chief Counsel, so it came from internal, not from TASB.
Good evening, board members, Mr.
As far as I'm
Hagerty.
not finished.
Oh, I just wanted to make one clarification.
Ma'am,
The
I have the
bulleted
floor.
points do come from TASB Legal Services. That's all I wanted to share.
No, they came from the TASB policy consultant.
No, sir. We
It
had,
says it right here, reflect, red line draft prepared by our TASB policy consultant
so
reflecting the
if
policy
you read
changes.
the board communication that
I have it in
was
front of me.
addressed to the board, the first line notifies you that our policy consultant with TASB has been communicated with, and she's the one that prepared that red line draft of the policy. Separately, TASB Legal Services was also contacted so they could provide their thoughts and some considerations for this board before the changes are made. What I went ahead and did was bulleted those items that were discussed with TASB Legal. So those are actually coming from TASB.
Do I get to continue?
That's all I wanted to know.
Thank you.
Thank you.
The child endangerment thing, that's state law. If something's going on with a child, they need to report it. There's no 10 days. That's state law. That's not local, that's not legal, that's none of that. The examples Mr. Safi gave regarding this is when it can go to 10 days, he said were extreme examples, meaning that it's not going to happen. If it is, it would be an extreme example. But then he went on further to say that they can be extended anyway. They can extend those days, just that, as he said, the employee has no say in the matter. So administration can extend these days out if they want to, but the employees, again, don't get equal footing. So we can not approve it because we have all these things here, which, again, I went point by point showing why they are inaccurate. When it comes to the other thing that Ms. Woodruff brought up, the policy changes being proposed could create inadvertent and unnecessary compliance issues. Can you please tell me the specific SB 12 conflicts that would create those inadvertent and unnecessary compliance issues, please?
So, Mr. Haggerty, some of the things that were included in the resolution, it's a very thoughtful resolution, and I'm not, I'm not trying to diminish that at all. I think that there are sections that require an explanation or some clarification. One of the specific areas is proposing that employees be entitled to all the same district records that administration is entitled to as it relates to a possible disciplinary matter. We have conflicting federal laws in particular that do not allow for disclosure of student records, that do not allow for disclosure of the names of witnesses, victims who have come forward with allegations of sexual harassment or sexual assault.
So then we can redact those names? We can redact the child information?
Quite possibly. The truth of the matter is this, because I oversee records and I've been handling FERPA records for a long time for a lot of school districts in Region 19. The problem is that most often than not, the requesting party is a teacher or someone who's familiar with the student's handwriting or with the facts of the allegation. So even with redaction, it's quite obvious the information or the person that is providing the information. So
then
we have
scan it and have it printed out.
So under FERPA, under current guidance, we're allowed to withhold those records entirely. And most often we do. We exercise the right to withhold those records. So that's one example of a conflicting
But it's
law.
not conflicting because you said that you make the decision whether or not to withhold those. And you could just scan the document and have it printed out in block format.
So I think that in order to get there, to what you're suggesting, language would have to be revised on your end. And again, I've offered to assist you, sir, and I'm still glad to assist you so that we can, I've communicated with you this week and offered to assist. And so
You didn't?
I did.
Then
But,
I didn't get the email because there wasn't a text message, there wasn't a phone call. But-
There's a phone call and a text message, sir, to which you responded. So the point of the matter is this, Mr. Haggerty. I'm happy to work with you because I think that there are sections that could be qualified and reviewed more thoroughly because, as Mr. Safi indicated, there are policies that are implicated by the aspirational language in the resolution. We want to make sure that the board, by virtue of adopting changes like this, aren't violating other policies. The SB 12 concern is that now, under this new bill, school districts, school boards are liable if they adopt policies and don't follow them. And this is part of the kind of taking away local control agenda, if you will. So I want to be very careful moving forward about what this board adopts or amends or proposes as far as policy.
And then if the board also reads, there was also a second motion that says before you deny this whole thing and throw it out, that there is another option in there that says a committee can be formed so that within 60 days, we can be presented with a new policy that takes into account everything that Ms. Mata is saying, but also includes association input, teacher input, community input, and gives everybody the opportunity to weigh in and have their voice heard and make sure that it reflects everything that everybody needs and is looking for into this document, and then present it back within 60 days for approval. And if you guys were looking at doing that, there is a second motion that would ask you to consider if the first one isn't, because you choose to believe what's written in this board communication. Thank you.
Mr. Hernandez?
Last week, at the board meeting, during public comment, somebody said that she's already representing employees at the district. Yet, what's being proposed today, this proposed amendment to policy DGBA suggests that that is not happening. Can somebody answer, are employees at YISD being denied representation during, I guess we call them disciplinary meetings? Is there representation happening sometimes? Has there been denials of representation? What's the truth of what's happening right now?
Good evening, Mr. Bustillos, members of the board, Dr. De La Torre. The individual that spoke at our last board meeting has reached out to me and asked to be in meetings, the disciplinary meetings that rise to my level, and she has been involved in those meetings. Sometimes she's not physically present because I need to take advantage of the situation immediately. So she'll be available by phone, and the meetings are tape recorded so that she can have access to it at the end.
Are members of the other teacher association, specifically the Ysleta Teacher Association, are they being denied representation for these meetings?
If it is requested by the individuals from YTA that they would like to have a representative present, then of course I would get them on the phone.
So you would not deny anybody representation if so requested?
The only time that I could see that it would happen is if there was an instance of significant abuse of a child. At that point, I would have to finish that meeting, and then I would involve the association. But no, sir.
Besides extreme examples, from your perspective, what does this policy change in your practice?
I think one, it would codify it, it would be placed in writing. The difference that it would be that is not currently in practice is that it also involves meetings with campus administrators that could potentially lead to disciplinary action.
Is there any concern about that?
I think that, well, in my opinion, is it could be overly burdensome depending on the situation, and I don't mean that disrespectfully to anyone. Some principals, will just say at a high school setting, have 50 meetings a day, and it would be really difficult for the representative that's assigned to that specific campus to be in all 50 meetings because they're generally teachers as well. So I think that the best thing would be to outline exactly when the representation is going to be utilized versus not utilized, so that we're not overburdening that teacher that is the representative or having to delay situations that need to be timely addressed. I hope that answers your question, sir.
Yes, thank you. I'll be honest, I was ready to vote yes on this. I think I still am. I don't understand, besides using extreme examples, what the worst concern is, what the worst case scenario is that come of these concerns. Would legal or anybody else, in simple terms, like to explain why this proposed amendment should not be passed today?
Mr. Hernandez, board members, I'll mention a couple of things that relate to the attorney-client privilege. One of the things that I read in the resolution is equal access to documents. If taken literally, that would include equal access to attorney-client privilege communications, which I would never recommend. There may be a situation where an administrator, in evaluating how to handle a situation, may seek legal advice. That legal advice may be given in the form of an email or a memorandum. And I would never recommend that the district waive its attorney-client privilege with respect to any advice given by its attorneys. Another example is the language that refers to the equal right to be in a closed meeting. Well, that's true to the extent that a matter involving the employee is being discussed in closed session. That's true. The employee has a right to be there with a representative, except to the extent that the board, after hearing the matter, desires legal advice on, okay, what are our legal options? What do you recommend, if anything, et cetera. And that, again, the employee and the employee's representative would not have a right to be there unless the board wants to waive the attorney-client privilege, which I would never recommend. So those are a couple of examples. Now, those can be addressed by, language such as except as exempted by law, or the attorney-client privilege, or other privileges available to the board or to the district. I mean, those issues can be addressed. But as worded, those, I think, are legitimate issues.
Let me make sure I understand, Mr. Safi. If this policy passes as worded today, that would mean that the district is waiving its attorney-client privilege?
Now, Section 2, Item 6 of the resolution explicitly states, except where representation would be prohibited by law.
Okay, well, the attorney-client privilege is not a prohibition. It's a privilege. It's a privilege. The district can waive it by the board. The board can elect to waive the attorney-client privilege. And
But passing this policy today does not mean that that will happen.
Well, the language that I saw refers to an equal access to documents, which could include an attorney-client privilege document, and a right to be present during closed session without any exception for instance, attorney-client privilege. I think those exceptions could be worked into the policy language, but I don't see them there now. I'll mention another issue is the resolution says that the representative would have the right to speak on the behalf of the employee. Well, that's fine if the representative wants to make an introduction, wants to make a concluding argument, and so forth, but I think it would, if taken literally, that would mean that the representative and not the employee would be answering all the questions. Again, that's if it's taken literally. What
difference does that make if the employee says, "Hey, I want this person speaking for me"? What difference does that make?
Well, everything the representative says is hearsay. It's not the employee.
But it's approved by the employee that's asking for it.
In deciding, for instance, let's just take a sexual harassment complaint. Okay, let's say it's what the complainant says versus what the respondent says. There are no other witnesses. Credibility of the witnesses then, of the two witnesses, there are only two witnesses. Credibility is critical. And it's very difficult to judge a witness's credibility if the witness is not answering the questions.
A final decision will be by the board, correct?
No, only if
If it goes to a level 3 grievance?
If it goes to level 3 grievance, that's correct.
And I think it will be taken into consideration if that employee refuses to speak on their own behalf.
I think
what I'm getting at is I don't see the big concern by passing this resolution as is today. I've asked for the case to be made. I don't think it's been made. I'll vote yes as it is. Thank you.
Would you like to say anything? Or I didn't want to go ahead and then I'll let you close. All right. Just wanted to confirm, we did get third-party TASB to look at this, right? Correct? Okay.
That's right, sir.
So then, I still want a lot to look at this, some time to look at this. There's a lot going on in here, and I totally respect Mr. Haggerty and the work he put into, but I know there's a lot more work that needs to go into to be able to convince at least just me to vote on this as yes. One of the items, Mr. Haggerty, that you put is a committee, and I'm looking at it, and you want one trustee. Usually when we do committees, there's two trustees, and then on the committee, there's no representation from the ones that are being, I think, looked at, which would be a principal or several principals to be on this committee to make it fair and balanced on that. There's definitely some work to be done, and I definitely like to bring this back. And in anything that we do, I think everybody here has said they don't mind working towards this. It's just continue working toward it to be able to reach all parties' goals on this. And I think that's the beautiful thing that we're doing today is talking about it and trying to see if we can meet everybody's goals on this. So for me, I am gonna vote no, but definitely looking to see if we can postpone this to maybe another meeting and see what Mr. Haggerty can negotiate with legal and working with our administration on getting closer to passing this through. Mr. Haggerty?
I think if the majority of the board is looking to postpone the item to have myself and admin review it and come up with a new proposal, I would rather see that committee formed because it would provide input from several different sources, and it's always been my opinion that the more brains we get in the room, the better off the document's going to be, the solution is going to be. So if I could make a motion, I would move to consider and approve of a resolution affirming employee rights and adopting amendments to board policy DGBA. Sorry, let me try that again. I would move to consider and approve a resolution affirming employee representation rights and the establishment of a stakeholder policy review committee to include a principal from an elementary school, middle school, and a high school, and 2 board members to revise and return proposed policy language within 60 days.
Would it be possible to add a representative from the Teachers Association?
That's already in the...
It's already in there.
Okay, sorry, I didn't hear it.
So we're voting on the committee, correct?
The resolution and the committee.
Okay. All votes have been cast. The motion passes 5-1.
Mr. President, I make a motion to adjourn.
Yes.
at 6:50. Thank you.
Huh? Yes, we adjourn. I'm sorry. Yes, we're adjourned.